Good evening, everyone, and welcome to the November 19th edition of the of Beyond the Data. And today we have with us attorney Mitch Marczewski, who you're down in Zanesville, right?
Yes.
That's east of Columbus.
Yes.
All
Yes.
right, yeah. So another attorney. This is great. We have all these attorneys suddenly showing up. We've been begging for you guys for like a year and a half now, and it's been really great meeting more and more attorneys who are coming out here. And
Yeah.
I first learned of you from an HFO, Health Freedom Ohio. Um, uh, my brain is just asleep today. You did a seminar for them on religious exemptions as well, and
Yes.
I mean what you're doing here I think is so important right now, because it seems like a small simple thing to go get an exemption, but when you have thousands upon thousands upon thousands of people who suddenly need one very, very urgently, I mean, it's what do you do? Who do you go to? How can you get help? And I love the fact that you're out there just giving all this advice for free, really, and just helping people get started at the least. And then if they need more help, you're there. So that's what you are here to do tonight, is to like walk us through the whole religious exemption process, and what our rights are, what they can do and what they can't do, and what you should be watching out for, and all that kind of stuff. So, anything else you want to add to your background or anything like that?
Oh, yeah. I've been. I'm basically a bankruptcy attorney. My passion is Chapter 13 bankruptcy and all the intricacies of it, and I just love it. And I know the husbands and wives just elbowed each other now, saying this is definitely going to be a long hour with this guy. But anyway, I've my daughter is probably the most responsible, in a way, in an inadvertent way, of getting me involved in what I call the medical freedom movement, which I'm so happy to be involved in. I'm just meeting the greatest people. And she's a fourth-year nursing student at Ohio University in Zanesville, the branch, and she was having difficulty getting her clinical placements because her instructors were telling her that even though the university recognized her religious exemption from vaccination, the clinical site, specifically Children's Hospital nationwide, would not recognize it. And so I knew she went back and forth with that with her instructors, and we're about six students that were kind of the holdouts that were not going to get the vaccine. I had a feeling that some manipulation was in the works, and so I wrote a letter and I hand delivered it to the dean. And the very next day, all six of those nursing students got placed, not at Children's, but they got placed at other spots. So they were playing a game of hide the ball. I mean, it's just very upsetting, the amount of deception that's going on in this whole with this whole vaccine mafia that we're dealing with, to be frank with you. And I don't want to offend Don Corleone here, but these are not nice people at all. And we need to kind of buckle up and gird our loins and understand who we're dealing with. These people take no prisoners. They don't care about you. They don't care about your job. They don't care about your health. They don't care if you eat. They don't care if you stay in your home or don't. All they care about is promoting what they promote. And
compliance.
Right. Yeah. Yeah. So, I mean, it's I hate to say this, but this is a very nasty game. And unfortunately, I was speaking last night in Orrville, Ohio, Wayne County, near the Smucker's factory, and those people are being treated terribly. One person, they're a third generation Smucker's employee. Grandma worked there, their mom worked there, and they worked there. And they're basically booting them out the door, denying that they have religious exemptions, making them jump through all these hoops, play these mental gymnastics to deny their right to have an exemption from vaccination. This thing is absolutely religion in and of itself. It's almost a cult, and those words don't come easily from a hard-nosed attorney like me. respects evidence and facts, and but there's no other conclusion that you can come to. And so I've decided that I'm going to help people. In addition to my other practice, I've decided that I'm going to help people get through this. And I mean, I'm representing, a few doctors right now. They're wanting to boot them out of the doggone hospital over this. It's totally ridiculous. Nothing like it. The law breaking that's going on, I feel like I'm a lone security guard at Walmart and 300 people are shoplifting right at the same time. It's just crazy. So, but anyway, yes, with regard to the exemptions, the easiest, there's medical exemptions and there's religious exemptions. I'm going to talk mostly in the employment context, but college students have exemptions. And of course, preschool through 12th grade have exemptions, which are much more generous and much broader, but I'm not going to talk about those tonight. The main one is the religious exemption under Title VII of the Civil Rights Act of 1964. And there's really four key legal terms that you're going to hear me mention. The main one is this concept called sincerely held religious belief. It's a very important concept. The courts have decided that is going to be a broad definition. That's good for the employee. That is good news for you guys out there, that it's a broad definition. So even if you don't belong to an organized religion, or you participate in it from time to time, or even maybe you go to different churches or practice even different beliefs, the Supreme Court has let that definition be so extremely broad that not only does it include the traditional beliefs, Catholic, Methodist, Baptist, we could name dozens of them, but also religions that are uncommon, unreasonable, illogical, and ones that lack any kind of formal organization, or even if they're not recognized by others. So the Supreme Court, in other words, you could even have a religion that's a deeply held or a sincerely held religious belief. You could be the only person on earth that really believes it in that exact way. And as long as it's sincerely held, you qualify as having that belief. It doesn't matter if you get a pastor's letter. It doesn't matter if you get literature. In fact, as I talk about some strategy on this, I'm recommending against getting pastor's letters. Never mind the pastor's letter. Never mind the literature, because all you're doing is you're opening it up to dispute, where some sharp attorney with a fine-tooth comb is going to go over all the pastor's letter, and then they're going to go over your statement, and they're going to find 5 things that disagree. Then they're going to get you in the office and want to argue with you. So we don't need that. It's not even necessary to begin with, and the law doesn't even require that. But,
so if I can stop you right there, actually, I mean, I have a question there. So what is there any definition of what it means to be sincerely held?
It comes down to, as the EEOC guidance states, that person's credibility. That's what it comes down to. That person's credibility. How truthful are they? How much candor do they have? All of the things that one would expect, even say a jury determining the credibility of a witness on the stand. It's that person's credibility. Now I know translating a lot of these concepts that are in the guidance and even in court cases, often there's large gaps of where the rubber meets the road. But that's the answer that would get you an A on the law school exam. It's that person's credibility. So when I go over with people, when they give me their deeply held or sincerely held religious beliefs, I just basically ask them back. Go ahead and read that to me or tell me what it is, and then I just say, is that your sincerely held religious belief? And usually, and if I get a quick, it certainly is, something to that effect, emphatic. And then I say, well, are you sure? They say, well, yeah, I'm sure. Why do you keep asking me that? I know that I've passed that test. And it's much simpler than most people are thinking. What's throwing people off, and this is very understandable, it's these crazy questionnaires that the employers are giving them. And it implies that they have to jump through all these hoops. But if this ever ends up in a court, and most of these don't, but if it ever would, That's not going to count. I just get the person on the stand. And I would even feel comfortable even introducing this way. I remember doing this in a trial once where my client was not a particularly nice person, but he did not commit this particular crime. And I was not going to let the prosecutor or the jury convict him on him being a bad person because he ran red lights all the time. And even before I gave my closing argument, I said, ladies and gentlemen of the jury, I'll tell you right now, I'm not even so sure my client is the greatest person in the world. I'm not sure I would let my daughter date this client. It was actually an F1 felony rape case. I said, but, and boy, we know how important that word is in the English language, because what comes after that word often negates what came 10 paragraphs before that. But that is not what we're here for today. We're here today to find out if the prosecutor proved beyond a reasonable doubt every element of the offense. And they ended up acquitting that client. So even in this situation, I would have no qualms even getting up in front of a jury. And again, most of these are not going to end up there, but an attorney has to do their job on the fact that it could be there, because 9 out of 10 will not go to trial. The problem is you don't know which 9. So you have to pretend that all of them may go at trial. I might say, ladies and gentlemen, jury, my client has a religion that is extremely unreasonable. It makes no sense whatsoever, but that's not what we're here for today. Your determination is, do you believe my client holds that as a sincere belief, and is his testimony on that credible? That's the only question that's before the jury. So that's
just basically whatever you say, always be consistent. And that's what your credibility is. And that kind of leads into this question here. And yeah, so can you clarify if the head of your church, say they call him the Pope, pastor, whatever, says the vaccine is acceptable, if in your sincerely held religious belief you are opposed to something, it's your belief that matters, not that other person's. Yes?
That is correct. Absolutely correct. And that's the classic example, actually. There's 70 million Catholics in the United States.
Yeah.
And, you know, I mean, during my lifetime, I think there's been 3 popes. And, you know, I mean, with all due respect to the Pope and the Catholics and everybody for that matter, the fact that a particular Pope is you know, in favor of vaccines does not negate your sincerity in that Catholic faith that you've had all your life when there's been 4 popes. And that, again, it's the sincerity thing. The courts have decided that you don't, and actually that's another bullet point on my notes. You do not have to hold to all the tenets of a religion in order to have it deeply held. Courts have held that it's pretty normal in the course of human affairs that we're not going to agree on all points of everything. But being that it's not about that anyway, it's about your sincerity, the courts have decided that's fine. You can still have a sincerely held religious belief and not hold to all the tenets of that. So that again, this is very generous to the employees. This is really good news. There are many times I'm doing law for somebody, and we've got this narrow gap that we have to navigate through, you know, thread the eye through the needle. And boy, it's tough. You know, the law is not on my client's side, but here's one of these situations where it is. Now, on the sincerity part of it, I just talked about you don't have to agree to all the tenets. Also, don't worry if your beliefs have changed. A lot of these questions are hinting on the fact, like, how long have you been believing this particular way? Don't worry about it. There's a first day for everything. Some people grew up in religious traditions since they were children. That's fine. Other people get to a middle age and decide that they, you know, need that in their life, and that's terrific as well. And if it so happens that the next week the mandate comes down and they became a believer, you know, 10 days earlier, it makes no difference, not at all. So the courts have thrown that out.
Well, it also is very convenient the last, 21 months or whatever. I mean, it's kind of like, yeah, I can really claim, yeah, I've definitely had a lot of time with myself. I have come to certain understandings about how I view the world. And I mean, it's, yeah, this is a perfect simple, straight up, okay, you're worried about dying and you think about dying and all that. Well, yeah, you can in the last few months understand that, yeah, you've changed your beliefs.
Yeah, for sure. I mean, there's a saying that life is a series of habits interrupted by a few thoughts. And oftentimes there are events that occur in all of our lives. And the one I always think of is funerals, where we kind of reevaluate, we're not getting any younger, and maybe we're need to establish relationships with people we haven't seen for a while, they're at the funeral. And then maybe sometimes we think about, hey, someday I'm going to be in a casket, where am I going to go? What's going to happen? And we do think of these things. So totally normal. And the employee should not be intimidated into thinking that they don't qualify because their beliefs have changed over the years, or they are a recent convert. If you've received a vaccine in the past, that's another red herring issue. That makes no difference. You can still have a sincerely held religious belief against this vaccine. And I've seen that on statements that people have written. And I know the hospitals often will provide this, this fact sheet. The Tylenol comes from this strain of the whatever, and so on and so forth. It's just totally irrelevant. The only time that they call that the interactive process, which that's permitted. That's another one of the legal concepts here. That's permitted, but that's only under the circumstance that if there's an objective base, like they're supposed to, according to EEOC guidelines, they're supposed to accept the sincerity of the religion unless there's an objective basis to doubt the nature or sincerity of the belief. So I've answered some of these questions. I did one yesterday. The question was totally off the wall. And I said, the only circumstance where this could be an appropriate question is if you have an objective basis to doubt the sincerity of my client's religious belief. And there was no objective basis because they couldn't have one, because this was the first questionnaire. This was the first piece of paper that was being filled out. Now, that ties into the reasoning of forget the pastor's letter and forget attaching literature, because what that does is that could give them an objective basis, because if it conflicts even in the smallest way between your custom, unique, personal statement and this doctrinal statement that you attach, well, now it's your fault. You've opened up the door to give them an objective basis. I had one today that was sent to me, very intelligent person, and it was a nice piece of literature to read, but at the same time, when I have my lawyer hat on, I'm thinking, I'm going to tear this thing apart. There's just so much in here. This guy's giving me so much opportunity here. And so I just cut that thing by about 2/3 and said, this is much better. This is a situation where less is more. And lawyers don't like clients that talk a lot anyway, to be honest with you. I can't, there are more situations where we've done a little too much talking that's got us in trouble, as opposed to not saying anything or not saying enough. So that's just kind of a presumption that we have kind of from the get-go. Like to talk about this kind of change gears. Many people, unfortunately, they've already been forced to resign. They've been told the lie that by not taking the vaccine, that's like the functional equivalent of a resignation. It's not. It's a resignation is a voluntary resignation is one thing. A forced resignation is quite another, or a coerced resignation. What you guys need to do, if you fell for that, is you need to, and I'm saying this in a hyperbolic way, you need to pound your fist on the table and still file a claim with Job and Family Services for unemployment, and still get on EEOC website and file a complaint, and still get on Ohio Civil Rights Commission website and file a complaint. And don't worry that it says you're too late to file the complaint. You file it anyway, because many things can be overturned in the law on the basis of fraud. And what some of these employers are doing, yeah, seriously, like flat out
like
fraud.
a lot,
big time.
A lot of fraud going on.
Fraud. Yeah. So yeah, go ahead and do it. And then you're going to want to build a paper trail. Lawyers like paper trails because it makes for good cases. I've had cases that were average, but the paper trail was so good, it turned it into a good case. And then I've had the converse, where it was like a really great case, And then I'm thinking, okay, can't wait to see your paperwork on this. And they say, I don't have any. Well, now it's a bad case. So this is something that is probably going to stick with us from the old, if you want to call it the old days. That's actually a good thing. Not everything that's old is bad, by the way. There's some pretty good things. Go into some antique shops sometime and see some of the handheld kitchen appliances that they've used to cut fries and peel potatoes and stuff. And it's like, why don't they make this today? This thing's great. But in any event, there's lots of these, the paper trail is really, and I'm talking real paper, I'm talking with put in a file folder. We use certified mail. When you file a complaint online, you're going to do a print screen on paper, and you're going to make copies for yourself. And you're also going to stick copies of that in an envelope with a cover letter. And you're going to send it certified mail to the agency that you're making the complaint to. And that you're doing this in case this ever ends up in court. And with the way this is going, they could say, well, you never filed a complaint. Oh, I filed it online. Oh, you did? You got any proof of that? Well, yeah, I was sitting at my desk. That's not proof. That's a he said, she said. But if you have a certified card, that little green card that's signed by the receptionist, then you've got proof. And I can wave that in the courtroom, say, Your Honor, they signed for this thing. And that's going to be treated as if delivered and received. So very important. And I know a lot of this stuff is kind of technical kindergarten type stuff. I get that. I remember a book written many years ago. It said, everything important in life I learned in kindergarten. And that, say please, be polite, say thank you, don't take stuff that doesn't belong to you. Us adults need to sometimes learn some of these rudimentary things and, build the paper trail, keep journals, keep a log. This is important stuff. If this is important to you, you're going to do this. And that way, if you ever end up in court or in a full-blown hearing, you've got good evidence, and it may be way better evidence than the other side has because they didn't do what they should have done.
No, and that's really useful because yes, there's simple tasks, but at the same time, it's not something you're going to be thinking about when you are really terrified that you're about to lose your job, and just knowing that, okay, this is what I need to do. I need to take a screenshot. I need to make sure there's a timestamp on it. I need to email it or whatever it is that's got a date on it. I believe actually Warner Mendenhall, I know you've talked to him as well with the Portsmouth case. As far as I understand from when I talked to him, that the employers in that case actually said that they didn't submit their exemptions. I think that was part of the case where they denied the TRO, is because they said, oh no, those employees, they never submitted any exemptions, and they had. So it might be an instance of exactly that. So you need to screenshot, take a picture with your phone, put it on paper, print it out, whatever it is that has some kind of a legal timestamp kind of situation on it. That's basically what you're saying, because otherwise you do get rejected. They can say whatever they want about you. And that seems to be what happened in Portsmouth. Yeah,
and that is correct. And the thing is the people that I talk to, the hundreds of people that I've taught, these are, you guys, and I'll just kind of speak to the audience here. You guys are nice people. You show up at work on time. You're honest. When it says you take the coffee break from 11 to 11:15, you take it on the exact time. You don't punch out and then, go, or drink your coffee and then punch out after that. The thing is they exploit your kindness and your, and maybe even some naivete in a way, and I don't say that in a disparaging way, but they exploit that, and we have to understand how these people think. We don't have to become like them. I think sometimes people are afraid to say, well, if I start thinking that way, then I'm going to become like them. I don't know. I think it takes a little more than that, but we have to understand that they're a crocodile in the water, and you're just kind of playing along the edge, and they're just going to snap at you. You're just a number, other than to your mom or dad and the people that love you, you're just a number to these people. And that's what I see happening to people. And it's very, very unfortunate, because these are some of the nicest people that I've ever met. I just love them to pieces and really want to help them. But we just have to turn up our sophistication game just a little bit, and just understand that these people, they play for keeps.
These are the bad lawyers. Yeah,
Yes,
I mean,
bad
also,
lawyers, the bad employers. Yes, absolutely.
and it's
Yes.
just as you said right there, where they're playing on your diligence and your naivete and all that kind of stuff. That's what all of these forms that I've been seeing, being put out there for. We're all the law abiding citizens, the hard workers, the ones who really, are just good, diligent, decent human beings. We are confronted with a form like that, and it is absolutely not in our nature to say, screw that, no, I'm not filling that out. It is I understand it. It's like a physical, I want to fill it out, I want to answer, I want to be honest, I want to tell the truth, but all of these things are designed to trick you into putting something out there that they can then use against you. And it's like, that's one question. I don't know if we can kind of segue into that as well with these forms, that these questionnaires and stuff. What do you do with that? Because some of these things I read and I'm like, man, that's they're trying to trick you. They're trying to trap you in. It doesn't matter how you answer the question. It can totally destroy you. And it's like, and it's all designed, it's all going to play on people's diligence and honesty and all that. And how, what do you do with this?
Yeah. Fair question. The approach that I take is, I call it a parallel plan, where we have a plan A and a plan B, and we execute them at the same time. And the first thing we do is we cooperate with their particular forms to the best of our ability. And here's what will help resolve some of the dilemmas on these forms. When, if we make a list of, let's just say, virtues, honesty, hard work, truthfulness, and I think efficiency and economy and standardization could even be virtues possibly. The virtue of truthfulness is a higher virtue than economy and efficiency. So when a form is such that you are now placing where we have to move truthfulness out of its top position, and we have to put, or let's say standardization up there, because we have to answer that question or it won't allow us to even go to the next question. We have to stop at that point because then they've been successful into, I guess, turning us into a quasi liar of sorts.
Mm-hmm.
It's like a perjury trap. So at that point, you're fully justified under the law to not go any further. You can do a print, and I'm really kind of big on just do print screens, and then you could attach a piece of paper and number out the questions, and then you can answer them with I'll just call it the highest virtue of truthfulness. And there is no reason why that would not be very acceptable to a jury of ordinary people, to listen to the dilemma that you had to go through and make this difficult decision. And you decided that, you know what, I can't do both. I'm going to do it truthfully. I'm just going to do it truthfully. And because I can't do it both ways. I can't answer it's a yes or no question. It cannot be answered that way. It's kind of like the kind of an old joke, but I'd like to be able to think of a different way to say it, because it kind of conjures up some bad images, but we've heard it. You get a guy on the stand, it's a domestic violence case, and you say, Mr. Jones, simple yes or no question, have you stopped beating your wife? Well, you're going to get an objection immediately from the other side of the courtroom. If he says, yes, I've stopped beating my wife, that implies that he's been beating his wife. If he says no, that means he's continuing to beat his wife. And I get it that that's how those questions are. So being that they're playing that kind of hardball, we are totally justified into deviating off their script and saying, we can't play in this ballpark. Your fences to hit a home run are 3 miles away. And nobody has ever hit a ball that far. So we're taking this into a ballpark that's the correct ballpark, the legal ballpark. So I'm big on the print screens and printing it off. And you can do a lot of what I call see attached, quote unquote, see attached. like if it's answered in a roundabout way in your personal statement, don't use torturous language to try to navigate around their question. Just say see attached.
All right, so I'm a little bit distracted here. I mean, because what you were saying there is like there was one of the forms that I had seen recently is what do you do when you have this? I finally found it. The good thing there where it's an online form, and I think actually this is what you were just answering there. So what you're saying. Start again. So this one is from Ohio Health, where the line is, I hereby acknowledge that Ohio Health requires associates and providers to receive the COVID-19 vaccine to reduce the risk of symptomatic infection and complications, including death related to COVID-19. And your options are acknowledge or do not acknowledge. Well, this is not going to prevent disease.
Yeah.
So I don't acknowledge it, but I acknowledge that in their world that they think this. But yeah. I mean, how do you even answer that? I mean, if you've got those two answers and it's an online form where you can't cross things out. Yeah.
Yeah. Okay. That's good, because that'll segue into because there could.
And there's a second question that's even more like, no, I should read that one to you as well.
Yeah,
I'm curious because I know there's a lot of people in Ohio who are working for Ohio Health who are looking at exactly this form and going, what do I do with this? Due to my occupation, work location, or duties, if I became infected with COVID-19, I may transmit COVID-19 to patients, other healthcare workers, my family, and my friends, some of whom may be at high risk for COVID-19 complications or death, even though I have no symptoms. And it's, again, deny, acknowledgement, or acknowledge. And it's just like, how would you advise somebody to answer this?
Yeah,
it's a bubble thing. There is no, let me write my comments in.
Right. Like on that last one, it sometimes you have to read them over several times. If you can acknowledge a statement that they're making without acknowledging the truth of the statement that they're making. You're acknowledging that they've made a statement. I have no problem with that. And I know we're getting into this kind of legal hair splitting that drives people crazy, but it's right. It's super. This is really important stuff. Yes. And
there are thousands of people who are looking at exactly those questions right now.
Yeah.
What do I do with it?
Right. That's where you can do where the part B of the parallel plan is we send a certified letter, and I can email my materials to anybody if they want, and I'll email them, and it's got the letter. I call it a cover letter because you're going to attach your personal statement to that cover letter. And what the most important part of that cover letter is the last paragraph. And this is borrowed out of contract law, and it's used successfully probably hundreds of times on a daily basis in this country. And it goes like this: please note that due to the restrictive and one-size-fits-all nature of the online and computer forms, the information I submitted may conflict with the information contained in this letter. Okay, so that's sentence number one. So right away, we're setting the stage, right? We're setting the stage.
I like it.
Yeah, it may conflict, Okay, now the next sentence is going to tell them what the solution is. So, okay, so it conflicts. Big deal. You told us something. What is your proposed fix? Therefore, the information contained in this letter shall supersede any and all conflicting information that may have been submitted by other means. And then it goes on to explain that in a little more. The online form is restrictive and does not permit me to fully and accurately notify you of the basis of my exemption. So the case is closed at that point. Any lawyer seeing this is right out of Contract Law 101. So right away, this letter controls no matter what even if you answered every question wrong, which obviously we're not going to want to do that anyway. But even if you did, let's say you bumped your elbow on the keyboard and it put a check mark in the box you didn't intend and you didn't catch it. Okay, fine. Well, this here explains it, and in court, and nobody's going to argue that. I'll tell you right now.
You documented, so long as you document that you are objecting to the system that they're trying to shove you into, then that's what lawyers are looking for. Because that's another thing is, I mean, I am not a lawyer. I am like, I've happily not had to have any reason to have experience with lawyers, and it's just I am very a direct person. I am like, okay, this is it. These are the facts, and done. I don't like the games. I don't like any of that kind of stuff, and it's just like that's really helpful to me, because it's that how do I approach something like that where I know they're trying to trap me, but to that. Legally, for lawyers, if you write something like that, you are you're set. That's good enough. That's what protects you from all of these kinds of forms that are online, bubbled, all that kind of stuff. And then you can timestamp it with the post office and the certified mail and all that. And that's how you show that no, you did this, which then goes back and proves that you are sincere.
Yeah. Absolutely.
I like it.
Yeah. They're done at that point. There is just nothing, and you're going to send that by certified letter to the HR person. I was wanting to put my email up there, and I found the proper spot to put it in case anybody. Yeah, Mitch at ohiomedicalfreedom.com, and I'll be happy to send.
You have it in the wrong comments, but what I'll do is I'll put it up on a banner right now for you, and that'll just be at the bottom of the page here, and there you go.
Oh, cool. All right, excellent. All right, yeah. So that takes care of that issue, and you're going to send it by certified mail, and I give you the form number, and you're also going to send it by regular mail. You're going to send 2 of them. And even there, if they don't sign for the certified mail, it might sit in the P.O. box for 10 days, but you're going to send one by regular mail, and you're going to get what's called a proof of mailing. And I have the form on there, the form number from the post office. So it's going to be covered really well.
Where do you have that?
Oh, I'm sorry.
What is it on your website where you have these forms and things like that?
No, I need to get with the program on the technology here. It'd probably take 10 minutes if I would sit down and actually do it. But I need to get that up on there, and I need to get some videos. There's people have been doing videos of me, and I say, I release the copyright, give them to anybody you want, post anywhere you want. But I've got to get it on my own website.
Yeah. Mm-hmm. Yep. I'm going through the same thing where it's just like, it takes a lot of time that you don't have, but it still needs to be done.
Yeah. But that's kind of the long and the short of it. Let me see if there's anything else here. Reasonable accommodations. My argument there, they ask in the forms, what is your suggestion for a reasonable accommodation? The best answer is stay with the existing reasonable accommodation. They were the ones that chose it. Presumably, they believe it's reasonable because human beings don't choose things for themselves that they don't think is reasonable. So I think the employer is even backed into the corner on that one, because for the last 12 to 18 months, the mask and social distancing or whatever, just say, yeah, just keep with the same reasonable accommodation. And if they say if there's an alternate accommodation, you can answer, I don't have any suggestions, but we can discuss that if and when the appropriate time occurs. Because the law does allow for changes on the reasonable accommodation if things change in the workforce. So if they're hiring more people, or they're moving one department down the hallway and they're putting desks in different places, and maybe they're going to have more people in a room or less people in the room, the law does permit them to change or modify reasonable accommodations. So I get a lot of questions on that where they're wanting to change it up. I do put in my particular letter that we're okay with any reasonable accommodation change as long as it's less restrictive. if it's more restrictive, then we want to know about it, and we would want to try to find a solution to it if it has a justification.
Yeah, I mean that's actually, I mean, you know, when we were talking about this earlier about what we're doing today, and that is one thing that I think is extremely important, because it's one thing to get the exemption, but I mean, you have to look at what all of these people are doing. They have one goal in mind, and if you understand that that is their goal, then you can understand better, or predict better, what they're going to do next. And their only goal, clearly, everything they have done, it all makes sense if you think about it in terms of their only goal is to have 100% vaccination in perpetuity for whatever they want.
Yeah.
And if you think that is, and if you understand that is their goal, then, well, first of all, you do go through this whole exemption process, and you try to scare people into getting the vaccine. And then the next step would be to make, even if you do get the exemption, make your life so miserable that you give in and you take the vaccine. And they're going to do it piecemeal. They're just going to just kind of scrape off whoever they can at each step until they get to the point where, you know, just peer pressure and that kind of thing is enough, that they've got enough people to push it over the edge and really make the vaccinated say, what's wrong with you, tiny little minority? We're going to take you down. So what do we do with these accommodations? I mean, just today, well, actually, I've been hearing this for a while now, where they're giving the accommodation is you're put on unpaid leave. That's not reasonable.
That's retaliation.
And also Cleveland Clinic, as far as I understand, I mean, the rumors have been going around that their accommodation for anybody who does get an exemption is like a 30 to 40% pay cut. You're not allowed to have any patient contact. And also your health insurance is going to increase. So right there, that means that you can't live anymore. You can't live on that money. You're working just the same amount of time. And if you already are like a nurse, I mean, where are they going to put you where you have no patient contact? And it's just like, this is not, yes, it's an accommodation. They haven't fired you, but you can't live on that. They're trying to make you quit on your own. And so how is there any legal way to fight that or prevent that? Or I think this is really where they're going next. And I mean, all the people who are going to push for their religious exemptions right now are going to be dealing with that. And what do we do, kind of thing? How do we prepare for it? Is there a way to fight it?
In a practical sense, it's, I mean, they're completely wrong. There's no question about that. They know the practicalities and the obstacles that the employees have to jump over to enforce their rights. It's formidable. They know that. You'll file your complaint. You'll do by certified mail. That's where I have a section in my handouts called Wild Cards in the Deck. And one of them is the employer could just basically be hard-hearted, where they're going to say, look, go ahead and sue us. We don't care. We have lawyers. We have plenty of money to pay them. Mm-hmm. Nobody's going to push us around. Just go ahead and sue us. We'll pay. If we have to pay settlements, fine. We'll pay them out. And there's nothing you can do about that, to be frank with you. And it appears that many of these larger ones, that's how they're doing it. Yeah. So it's one thing, it's kind of like, you're crossing the street and you have the light and the guy doesn't stop and he kills you. You were right, but you're also dead. And, I mean, it's a sad thing that we've come, not to expand the conversation, but it's a sad place that we've come to, that we're talking about this in these terms, and that people are willfully breaking the law and just saying, okay, fine, you want to sue us, go ahead.
Yep.
We'll see you in court. We'll make sure your legal bills are going to be as high as ours. And
Yep.
yeah, maybe you'll win, but we're going to teach people a lesson that it's going to be really expensive to come after us. And that I don't say that with any kind of great joy. I mean, I like justice. I like fairness. I like people being treated properly, and especially since there's no gain to treating these people improperly. What have they done to you? You're actually, they're actually hurting themselves. That's how the kind of madness that we're on the border of here is, that people, I say people, these institutions are actually inflicting harm on themselves at the same time they're inflicting harm on others. So you have a lose-lose situation. It's not even a win-lose. Like, well, we win because you're not here any longer. It's like we lose too because you're not here any longer, and you lose because you're not here any longer, and your kids lose because they can't be in soccer and band and play in go on field trips anymore. So it's kind of a strange madness that we're bordering on here, and it's very very
Depressing.
bewildering to try to understand it.
Yes, most definitely. I mean, it is. I mean, again, it's also a thing of there's got to be some other financial incentive going on there from
Yeah,
a administrative perspective, because
that's
who's
a good
gaining
point.
out of all this? There was there was just an article I read last night saying that the Columbus hospitals, I think they said the 3 Columbus hospitals all had record high profits. That their income this last year was record high, and it's just like, what? I mean, this is madness. And I posted just yesterday as well, where with remdesivir, straight off of CMS's website, the reason why they push remdesivir in hospitals, it's written right there. It says that with remdesivir, if you give remdesivir to somebody who's COVID positive in the hospital, you get a 20% add-on bonus to your normal reimbursement. So you get reimbursed as normal for giving remdesivir, and then you get 20% added onto it. And so it's just like, that's why they push it, even though they know it's got a certain fatality rate to just the drug. And so it's like, how do you, I honestly think that what they're doing here is they're just making those who are decent people get so disgusted with it that they walk away, and it's only the ones that keep perpetuating this that will remain. And that's one of the reasons why they're doing the self-inflicted harm, is that they're getting rid of all the people who might say, no, this is not okay. And so you get rid of all those people who could come out to lawyers and say, hey, our employer is doing this for the money, or whatever kind of fraud they might be pulling off, and you remove those. Maybe that's what the administrations are looking at, is just like, no, we need employees that are fully compliant with whatever we tell them, even if it hurts us in the short term. We need compliance, and that's it. I mean, I still do try to wrap my head around how can you have these institutions quite literally murdering people? How is this possible? I mean, it's just it's mind-boggling.
Actually, what you're saying is, in its own sense, it's very logical and rational, and we're they're probably looking at it from a completely different angle than we are. Like, we care
not
about
logical,
people.
rational.
Yeah. Like, we want people well. We want them enjoying life. We want them happy, feeling good, not needing drugs, not needing the hospitals, not needing to go to doctors all the time. And that does not serve their interests. And it's I think under any ethical or moral or religious system, it's just absolutely wrong. What they're doing, just completely outrageous. But we do have to fight. We are winning many of these at the federal level. The governor of New York, Kathy Hochul, did a executive order. Everyone had to be vaccinated that was in medical care. And according to her, she was not going to give any medical or any religious exemptions. And so a lawsuit was filed in the district court, said she could not do that, put that on hold. She appealed it, and the Second Circuit Court of Appeals agreed with the district court. You cannot unilaterally state you're not going to allow Title VII or exemptions. It's just not going to happen. Same thing, University of Western Michigan, they had vaccine mandate for the athletes with no religious exemptions. Lawsuit was filed, federal district court did an injunction. You can't do that. You must allow for religious exemptions. School appealed in the Sixth Circuit Court of Appeals in Cincinnati, which does 4 states, Michigan, Ohio, Kentucky, and Tennessee, agreed with the lower court. You must allow exemptions.
And that's why right now, what are they doing? They're like, okay, yes, you can have your exemption, but now because the only goal in their mind is 100% compliance with the shot. And so they've dealt with the courts, and the courts are saying, no, you have to have the exemptions. So their next step is we're just going to make our accommodations too painful. And so now we're on to the next step, which is exactly that. How do we deal with this accommodation issue? One of the questions up there as well, when you said, oh, whatever you've been doing right now, that must be reasonable, right? So one of the questions earlier up there was about testing. If a whatever institution was not testing before, is it a reasonable accommodation to then have testing after?
Yeah. It's gonna depend on the circumstances. If the circumstances have not changed, I would argue that that's retaliation. And you can file a complaint separately for that, by the way, where you can, and I think on one of the webcasts I was on, and I tell people I learn from my clients like all the time. And I learned something even speaking the other night of a certain strategy that a person was doing. And I said, that's excellent. I really like that. But the one is she secured her reasonable accommodation, got that under her belt, and then she worked on the getting an exemption from the mask wearing. But she didn't try. What I liked about it is she didn't try to get the whole ball of wax at once, because then you could lose both. She did it in increments, and that would be the way to do it, especially if it's one of these invasive ones where the swab goes way up the nose. It damages sinuses up in there.
So here's a legal question here as well, because I mean we were having a conversation before we went live as well, and I told you about the fact that it is against federal law for anyone to mandate anything with an EUA, under an EUA. All tests are under an EUA. So if you have a person who gets the exemption, and part of the accommodation is that they have to be tested, would that be considered mandating the testing, or would it not? Because that might be one way to, kind of weasel your way out of it.
Yeah.
Is that mandating legally? Would that be considered mandating, or?
Yeah, no, you're making a good point. I was not aware of that. And I mean, on the face of it, it would seem to me that there's a real conflict there. What
is the definition of a mandate legally would be a wonderful question if somebody can answer that, because again, that makes a big difference, especially with the vaccines as well, because there's still some wiggle room with Comirnaty because it's only partially, it has a biologics license approved, but it is not fully approved as a vaccine. It can be used under the biologics license as a vaccine, but it is not a vaccine. It is not approved as a vaccine. So is it approved? Is it not approved? I don't know. But of course, Comirnaty is not available. And so it just, by default, everybody has to use an EUA product. Is that mandating an EUA product? I mean, it's such a mess. I mean, what are the legal terms? Can you get away with that? I mean, that's I guess my question there when it comes to the accommodations. How would you set this up? How would you set it up in the way of, if you want to try and go down this route and say, oh, yes, you may test me, and then after you get your exemption and accommodation, then say, well, actually, you can't test me because that's a mandate. Is that the best way to try and?
I think so, yeah. And obviously, a person would have to be well researched. I answered a question last night, I recall, and with one gentleman, and what I told him, I said, the first thing you need to do is you need to become the resident expert on tests. Just learn all about all the different tests, what they cost, how long they've been in existence, what do they test, how accurate. I said, and he was a blue collar guy, but he was a smart guy. I said, that's where you begin, because when you're I think he worked at Smucker's, I think, but when you're known as the guy that knows these tests inside, you may not know anything about vaccines or viruses. Okay, that's fine. But you're going to be the guy that knows doggone everything about these tests. And that gives you I mean, you know, like it's often said, knowledge is power. And when people know that you have that knowledge, you're just going to get a whole lot further. So I kind of gave him a bit of a homework assignment of sorts, and I suppose I need to do the same thing.
Well, I can hook you up with a lot of that. So.
Oh yeah, I'm sure. Yeah, I'm sure. But yeah, I mean, then you can, boy, I mean, there's just no better, stronger arguing position when you are just so thoroughly versed on a certain subject, and that particular subject is the subject that's at issue. I mean, it's just, it's kind of like experts in the courtroom. You get an expert in some extremely narrow field, like liver or kidney or pancreas or something. I mean, like, even just your general internal medicine guy is just going to sit there and be silent,
Well, they don't know a lot of this stuff. I mean, a lot of the immunology stuff, it's clear that the doctors don't have a clue, because it's like, this is like the super most basic thing. Well, you don't have circulating antibodies. Whoop-de-doo. If you've ever had circulating antibodies, you almost certainly, unless you've got some other kind of severe immune dysfunction, you still have the memory of that antibody in your body. So if you do get exposed to the virus again, your T cells will kick into gear. You might get sick, a little bit mildly sick for a day or two while your antibodies increase, but within 48 hours you're right back up there. So this whole concept of this last bill that was passed out of the House of the Ohio House of Representatives yesterday, HB 218, where they had, you can use natural immunity as an excuse. Well, that whole thing it removes natural immunity, because it's nonsense language. And one of the things they said in there was that the Ohio Department of Health would be able to would determine how frequently a person would have to be retested for antibodies. No, you've had antibodies. You have antibodies now. You will be immune in the future. Once you test positive, that's it. That's basic immunology. I mean, it's,
yeah.
Doctors don't seem to know this at all. They're like,
yeah,
and it's just,
yeah.
Just because you're a doctor doesn't mean you know anything. That's what I've learned.
Right. Yeah, for sure. Yeah. I mean, even a lay person, like I've often talked to, just kind of on that subject, but just a little bit of a digression. I do not do a lot of real estate law, and a real estate agent who has sold a lot of real estate probably knows more about real estate law than me. And I admit that. I've said that many times. So that person, they're a lay person when it comes to law in general, but they're an expert when it comes to real estate law. And I'm the lay person when it comes to real estate law. And I think if we transfer that concept over, like that gentleman last night, he's a blue collar worker. He's a smart guy, I could tell. I'll bet you he could learn that. And he probably, I would bet my house that if he really made up his mind, he could know that testing better than any doctor in that town. And I mean any doctor. Seriously, I think that's within a person's reach.
Oh, yes. Oh, absolutely.
We often don't give ourselves credit. We just automatically think, well, I'm not a doctor, so like, why should I even try? I would, very beg to disrespectfully disagree. You're smarter than you think. And if you're just doing that one narrow topic, you're doing that one narrow topic, I think you could easily know more than all the doctors in that town. So anybody listening, there's an idea for you right there. Become the resident expert on testing. People will come to you. The HR people will come to you because they'll know that you know.
Yep. And that was one of the reasons why I started my very first group and the second group and the third group, is because exactly that, where how many times have I seen, oh, well, you're not a doctor, you're not a virologist, you're not a whatever. Who cares? Yeah. I mean, we are intelligent human beings. It's the one thing that is affecting every part of our life, and everybody is intelligent enough to follow this. Sure, yeah, maybe, hyper intelligent people might do it faster. But people who are, not hyper intelligent, just average people, they can understand it just as well, if not better, because all it takes is you just go in, you understand it thoroughly. And then once it's in there, once you know how to go about learning it, finding it and all that, and you can push it back. And here. Can you hear me now?
Yeah, you froze up for maybe 15 seconds. Yeah, your video froze and your sound, but I hear you now. Okay, yeah.
How weird. Yeah, it seems like I'm being silenced again or whatever. Somebody's messing with my internet. I don't know. I've upgraded my internet.
Yeah.
I have issues, I guess. I don't know. Somebody's trying to censor me all the time. It's crazy. Yeah. All right. So.
You're locking up again. So I'll just wait until you.
Where did I get cut off? Oh.
Okay. I can. Yeah. You locked up again. Yeah. You locked up again.
I do not understand it. It is extremely frustrating. This is the first time in a while, though, that it has done this. So am I still here? Am I still here or not?
I can see you, but it keeps locking every 3 or 4 seconds.
All right. My internet says it's okay, and just about everything is shut down at this point, so I shouldn't have issues.
Okay.
Am I stable now, at least?
Yeah.
So maybe something was just eating something up. I don't know, but everything is closed. All of it is closed. Okay. So hopefully I'll remain stable. So where did I get cut off there?
Boy, what's going on? Yeah. Talking about the average person being able to learn a kind of a narrow medical subject.
Absolutely. And understand the data better than the data scientists. There's absolutely no reason why we can't do that. And so long as you do it and make sure that you back it all up with official sources, if you can point to exactly the website or the official source, then they have no ability to speak against you. Always use their words against them. That's pretty much my mantra there. That's your words, that's your data. Well, what do you want? Then you know it.
Yeah, absolutely. Yeah, for sure.
All right. So let's see here. Go on.
I was going to say, just maybe another couple of points here, another wild card in the deck. I don't know if it's a wild card in the deck, but basically a lot of this comes down to the employee's risk tolerance. Kind of like when you sit down with an investment advisor and they say, we could get higher returns, but there's higher risk and lower returns. What's your goal? What's your age? Everybody needs to have some self-examination and find out how you're wired. Some people are high risk people. they'll roll the dice. If they get fired, that's fine. They're just, I don't want to say they're just as happy, but they don't have any regrets. Then other people are in situations where, like for example, one gentleman I talked to, he was the only breadwinner. He had 3 children, and his wife has multiple sclerosis, and he has insurance on her through the company. Well, that person is very unlikely to push the envelope. They often are just happy to be exempt from the vaccination. They'll wear as many masks as you want them to wear. They're happy. And then I've had other people, like a single guy, his car's paid for, no kids. He just says, I'll just move in with my buddy, and they can fire me, and I'll just wait it out. No big deal. It's not going to interrupt his life all that much. And it's not an answer of right or wrong. And it's not even a situation where if we get enough lawyers in the room, we're going to come up with this quote unquote right answer. The right answer is the one that's right for you. And I don't want to overuse that term, because I think there are absolutes in life. But when it comes to a subjectivity and value judgments of what's important in your life, as compared to what's important in somebody else's life, the lawyer is often of not much use, frankly. So that's just an important thing. I mean, there's lots of things that can be done, and a lot of them cost a lot of money too. And you can't ignore that. I mean, asking somebody to file a case, even a complaint, you're asking that attorney, okay, and get an injunction or whatever, I want you to work for the next, 40 hours or 50 hours or 60 hours. That it's, so other cases have to go on the back burner. You're thinking and sleeping and drinking that case. You got to depose people. You may have to get experts, and all that stuff adds up. There's just no way around it. If anybody has an idea how to file cheap lawsuits, I'm all ears. You give me a call. I'll pay a consulting fee, because I just haven't found a way to do it. The research is enormous, and the specialized research services, the LexisNexis and the Westlaws, are very expensive. And it is what it is. So it's not a shortage of finding a case, finding somebody that's been wronged. There's no shortage of unfairness. A lot of ducks have to line up. Also, another thing, and this would be with lawyers that are wanting to establish precedents, maybe more so than wanting to just fix a particular wrong, is that good cases make good law. So you look for cases that have things that are lined up on your side, like right off. Not necessarily easy per se, but where the right issues are going to get debated and that need to be debated, and that actually some judges are looking for certain issues. They want certain kinds of lawsuits. I've been to seminars, and the judge we'd be talking about a certain area of law, and the judge would make a comment. He said, now I'm waiting for one of you guys to bring a lawsuit on this so I can rule on this issue. So what that told me is they knew there was maybe a what they call a split between the circuits, where the Sixth Circuit appeal court ruled one way and the Ninth Circuit out in California ruled another way. And there was a judge that was just chomping at the bit to really make a ruling on that particular case. So there's lots of factors that go into that. But the main one, to be frank with you, I mean, it's just money. I mean, these are middle-class people. They got families. They're good people. And it's, so you just have to fight with what you got. Somebody's breaking in your house, you got a coffee cup and a fork in your hand, and that's it, then use it. I mean, that's all you got. So I know a lot of these need to be brought, but they're extremely time consuming. And you got to remember, these companies have plenty of money. They have absolutely plenty of money. And they will paper you to death. Mm-hmm. I've been involved in them, and I'm telling you, these things absolutely consume your life. And oftentimes, when you're getting a bill every month from your lawyer for $800, and then another bill the next month for $800, and the third month you're on the phone with the lawyer, say, when's this thing going to be over? And then I tell you, we got 2 more years. You don't want to hear that. And so I try to get that to people in advance, that this is just because you're right, which I believe that you are. I don't even hardly. There's too many cases out there. I don't even want the ones where they're not right. I don't even want them. They're no fun. You're wrong. Let somebody else do it. So maybe it's somebody that's starting out or whatever. So I mean, that's not really even the issue. And then often there's a thing, well, what about a class action? Well, what that does, that multiplies your work. I mean, it multiplies your payoff. But if you've got 30 plaintiffs, you've got to do 30 depositions, and they might have worked for different people at the same company. And it just adds another layer of complexity. I'm not saying there's not a place for them, but what I'm saying is they're not less expensive, that's for sure, doing a class action. So there's just limitations here that are not your fault. They're not the fault of the employee, no doubt about it. But good lawyering just requires, some of the older lawyers on their business card and would say, attorney and counselor at law. You've got to counsel your client and be very realistic about what the journey is going to be that they're about to embark on. And, it's like, hey, I want to go hiking, right? Oh, let's go to the Appalachian Trail. It could take you days to go there. You better be in shape if you're going to want to do the Appalachian Trail. So a good guide is going to explain that and say, no, we're going to do the small half-day trail first, and then you're going to do some exercises and change your diet up a little bit, and then we're going to do the one that's a little more. And that's a very important part of a lawyer's job, frankly, is sitting down and setting realistic expectations on these things. And I get it. These people are wrong and they're mean and nasty. I get that. But we just absolutely have to be realistic as far as what our resources are that we want to put into them.
Yeah. I mean, and they have resources. Uh-oh. Got a little bit of going on there. Is it coming out of me or you there? Oh, now it's gone, whatever that was about. But I mean, I had talked to Warner about the case he did with Portsmouth, the Portsmouth workers, and their hearing, they had their TRO, the temporary restraining order, denied yesterday. So 200 employees just lost their job today. And it's just like, and what he said is that the other side had 10 lawyers on that, and they're loving it because they probably made $100,000 yesterday just showing up, and it's just Warner and one other attorney in his office on their side, and it's just like how we need to understand that they have infinite money on the other side. Basically, it's infinite. I mean, it's coming from the government, is just printing money, whatever it is, and there's infinite money on the other side. So we have to find either ways to collect that money and get it to the attorneys doing the work that actually leads to something and not just into nothingness, or we need to find a way to crowdsource it as well. And that's, again, one of the reasons why I started my group was, okay, we got to have a whole bunch of people who understand the games that Ohio at least is playing, and how we can pick it apart so that we can then, put a little bow tie on it and say, here, lawyer, go take this and go take it further, which is another reason why I have volunteers and all that kind of stuff. Is just, okay, they have infinite resources. We just have us, but we're pretty cool. We can do all that work because it matters. It really matters. It's our lives. It's our children's lives. It's all that. So if we can get that, all of the knowledge that all of us have in different locations, and if we can bring it together to support some of these cases, I think that would be the most powerful thing we can do. Because we don't have that money. We can't pay $100,000 for 10 lawyers in a single day. We just can't do that.
Right. Yeah, it's not doable. The good news, I think we're getting there. I really do. Yeah, I mean, I'm encouraged. I'm going to be speaking. I was asked to speak up in Lake County to I think it's Stand Up Ohio group. His name is Jason. I forgot his last name. He gave me a call. And he's going to be raising.
Ohio Stands Up?
Yeah, Ohio Stands Up. Yeah.
Yeah, Jason Hedges. Yeah.
Yeah, Jason Hedges. Right. Yeah, I talked to him the other day. Great guy, first time. Yeah. And he asked me if I would come up and help fundraise to help fund. I said, absolutely will. I think we're getting there. I'm encouraged. I know it's a big mountain to climb, but I think we're making progress. And I also think we do have some advantages. We can turn people out and camp out on lawns and on sidewalks and do things like that. I see that still building, and it gets people's attention. it's a long-term strategy. It's not going to change next year or maybe even the year after. What's important is we're making progress. That if we consider that, we're making progress. We're closer to the goal than we were before, and we are getting some important victories like the ones I mentioned at the federal court level. And there's more that I could talk about, but I'm very encouraged that the federal courts are not allowing governors and universities to just blanket, you can't get religious exemptions. Now, I get it, and you're right about that, because the battlefield, it shifts. Now it's shifting over to the undue hardship, and boy, are they going to make it an undue hardship, all right, an undue hardship on you. And so, yeah, the battle's going to shift there. And
sue on that one to get the exact same response from the courts, and then it'll shift to something else.
Yeah,
we'll see. We'll see how that goes.
Yeah. But I'm encouraged. We should not be giving up. If anybody who's listening, don't give up. If anything, let me tell you this: fight for your honor. And I've told this to my daughter. She's the youngest of four. She's 21, still at home in nursing school. I said, name is Kate. I says, look, Dad may not win this. We may end up broke, and we'll be living in that little travel trailer we have on a piece of property. But we're going to have our honor. We're going to fight for our honor. We're guaranteed to win that, and we may win some of these other things. We don't know. We're going to try, but we're fighting for our honor, and we will absolutely get that. And if that, just speaking for myself, if I've given it all I've had and the Giants were just too big, okay, so be it. It didn't happen. Nothing, left it all on the field. I'm going to the grave with my honor, and my kids could say, at least Dad fought tooth and nail. He didn't pull, he scratched, he used everything he had within his reach to fight. And at least that's an inspiration to the next generation that they should fight and how they should do. If we give up and they see that we give up, they're going to give up. And then it's definitely over. You're guaranteed to lose if you don't fight. They said, what's the guarantee? I said, there is a guarantee. If you don't fight, you're guaranteed to lose. That's a guarantee. We're not guaranteed to win, but if you don't fight, you are guaranteed to lose. So yeah, don't be discouraged out there if you're listening this tonight. And we've talked a lot about the obstacles that are in our way, but we're still plugging away. And I'm optimistic. I was born bright-eyed and bushy-tailed, and I'm optimistic. Yes.
Well, clearly I haven't given up hope yet, despite whatever it is now, 21 months of madness. So there's a couple of questions over there in the comments here, a little all over the place here. How's this one here? So what about unemployment if you're fired? Should a person go and miss work to get fired, to force the issue?
Oh, that's an interesting question. I'm not sure I understand what by miss work to get fired, but let me address the part that I do understand.
Well, I think it is about like so the issue of the accommodation. So if you are paid less, they've basically solved the problem of making you resign, as opposed to, I mean, I think that's what she means there. Okay. I mean, that's actually pretty, that would be something that an employer would do, is that they trap you. They're still paying you. Now you have to leave your job. They're not firing you. They're just making it unlivable. So is that a reasonable way to make yourself get fired, is just not show up to work and take the half money and say, fire me? I mean, does that work, or can they sue for it, or legally? I mean, I'm just thinking that through. That's actually a good way to do it when they do this, because they will do this. So just stay home, take your checks, and do no work until they fire you so you can get unemployment. But then how does that work with unemployment law? Can unemployment say, well, you just sat around and that's why they fired you? Right.
Yeah, no, I don't know. I don't think that's going to work. I have to hand it to them. They're coming up with new stuff, and they're pretty doggone clever. I mean, if anything, this cat and mouse game, I think, is making all of us smarter. You got to
find this way. Well, I spoke to at the march I was at in between Cleveland Clinic and UH today. Probably a few hundred people there. Employments of those two hospital systems there, and that was a great turnout and stuff. And one of the people I met there was a flight attendant, and they had, the ones that have refused have now been put on unpaid leave. And the one that I talked to, she's been working there. I can't remember if it was 20 or 25 years. She's one year away from being able to retire. But one of the stipulations for taking your retirement is that you have to be active. So you cannot retire from being on leave. And I mean, I can't even imagine this situation here where in order to get your retirement benefits, you have to take a shot because they won't put you back on. They keep you on leave perpetually. So you can't retire unless you take the shot. I mean, they are going to get really clever with how to punish you. And we've got to think ahead of the curve here and how to counter. I mean, that one is a situation. What do you do?
That's a real dilemma. And I think even legally, there's a whole nother, I mean, there's several legal theories. So, that would be something I couldn't even touch because I don't know anything about, retirement benefits law. And, that's a whole nother area right there. But yeah, I mean, there's no doubt it's a huge dilemma. I think the avenue, the more I'm thinking about it, I think the avenue is basically a harassment and a retaliation avenue through EEOC and Ohio Civil Rights Commission. I just think stick with that, because if it walks like a duck and talks like a duck, it's a duck. And they're calling it unpaid leave, and they're saying, well, we can at any time decide to pay employees less. Yeah, I get that, but there's a strange coincidence here. It was right after they requested a reasonable accommodation, and I think a jury would connect the dots. Those aren't hard dots to connect. So I mean, as a theory, and if I'm in law school writing my answer to my exam, I mean, I'm going to write that down. Now, again, I get it back to as far as where the rubber meets the road in real life, actually filing the complaint, filing the lawsuit, having the money to fund the lawsuit. I get all that. But I have an answer to the question as far as like just a strict answer that would get an A on the law school exam. It's just hard to transfer that out into real life unless we, and maybe Stand Up Ohio will end up
Ohio Stands Up.
Or I'm sorry, Ohio Stands Up. Sorry, Jason, Ohio Stands Up. Maybe they'll end up being let's just say the premier organization where that will be their niche, where they see that this is where this is where the battle lines need to be drawn, and where we need to really dig our shovels in is to raise huge amounts of money so that we can have as many attorneys as they do. And Pam Popper out of Columbus is a big believer in that.
Better. We don't need to be more. We just need to be better.
Yeah. I feel so bad for the dilemma of that person. I really do.
I can't.
Heartbreaker.
So one thing that you talked about here, and to understand what the legal term means, because a lot of all of these, going back to that whole accommodation issue, because that's where they're going to attack us next. Yes, they'll accept those religious exemptions, and then they're going to give you an impossible accommodation. That is absolutely what is going to happen. So everybody gets their religious exemptions. Cool. Now you've got to deal with the next thing. So to kind of get ahead of that curve, you have mentioned that, there's a difference here. There's retaliation. What legally is retaliation?
I think it would fall mainly on pleasantries in the work environment that have no justification to them. If I want to stick it out broadly, and it could take, many forms. You're eating separate in the lunchroom. I think the stigmatization, that's the other thing too, falls along the line. You got to wear a special decal. You got to wear a face shield. Nobody else does. Yeah, and you can file complaints on that through EOC and Ohio Civil Rights Commission.
So can you give me an example of what would not fall under retaliation as well?
Oh, that's an interesting question.
To try and figure out, okay, which group is what? Because because then you can figure out what you can fight and what you can't. If we know what is a retaliatory, I can't say it. You know what I mean. What is that and what is not, and to be able to have that, because what all these people need is, we need, just as you were talking about the guy with the testing, you need the confidence to say, no, this is what this means, and so therefore you're full of crap. So we need to know these terms. What does it mean legally? Where is that line between it? So you can say to your employer who gives you that, you got a 50% pay cut, basically. Well, that's pretty retaliatory.
Yeah.
So, but where's the line between, so you can have that confidence to say, this is absolutely. Is there a way that's defined? Can we define the not versus the is, and get a better idea of where this is, and so we can fight it?
Yeah. My answer is, you make the argument, you create it. No, and I really mean that. If they're treating you, I mean, anything that's different, that just to be frank about it, that you don't like, let's make, yeah, I mean, seriously, let's make an argument that's retaliation.
I hate the law.
I'm sorry?
I hate the law. I like boxes.
Oh, yeah, right. No, I understand. But actually that's what they call and you may have heard this, there's questions of law and questions of fact. And what is retaliation would be a question of fact for the jury to decide. So I would get up in front and say, ladies and gentlemen of the jury, they're making her eat separately in the lunchroom. She has to wear a face mask that nobody else does, and they cut their pay. And the attorney for the other side is not arguing that has nothing to do with retaliation, and it's all at the exact same time. And we're arguing that it is. And so you need to go into the jury room and decide if that is retaliation. And we believe that it is, because you can't have that many coincidences happen around the same time.
Well, they would make the argument that each one of those things that you listed there is because those are the the NPIs, the non-pharmaceutical interventions, that these things they prevent the spread of COVID.
Oh, right, yeah.
So you just have to, basically, you need a lawyer.
That's where your experts come in. Yeah, I mean, that's why these things are expensive, because you're going to have because they're going to say, well, we have reason, they're a direct threat. That's another term used in there to others. And then you get your experts in there and say, basically, you're going to prove that they're not a direct threat, and they've never proved that. They've just said that they're a direct threat. And so, so that,
they're no different than the vaccinated either, because the vaccinated have they have the exact same viral load. So
Correct.
You can't treat those two differently if you're going to do that. That makes sense as a way to fight that back. Yeah. So basically, when it comes to what is retaliation versus what is not retaliation, is simply how well you can argue it.
Absolutely. Yeah.
Is there because again, obviously we have so few lawyers, and money is limited. Anything that can be done straight between employee and employer is definitely what we need most of all. So is there, I'm trying to figure out how to ask the question, but is there some level of retaliation where you can really just say, this is self-evident that it is? If that makes sense, the question.
Right. No, I think that's a good question. It's just going to depend. It's almost kind of like a gut call. Yeah. It's kind of like going back to, I think it was 1973 case defining pornography, the U.S. Supreme Court, and one of the justices says, I can't define it, but I know it when I see it.
Yeah.
And I think
there's no real good way for an employee to just easily say, here's, like, for instance, it's against federal law to mandate something under an EUA. That is cut and dry. If you have a product that is an EUA and you are mandating it, well, bye, that is illegal. We're done. And that there is no such thing with retaliatory. So basically it involves a lawyer is unfortunately what I'm understanding here.
Yeah.
Ooh.
Yeah. So the person, actually it does not really need a lawyer. Just go from the presumption. Because again, these are not nice people. So we don't mind, not giving the benefit of the doubt, right? Like we're among friends.
You don't get any benefit.
No benefit of the doubt. So I mean, other than something like, well, they look at me wrong. Okay, that's too hard to prove, or they're, any change in the working condition, in the job duties, in the pay, that is less desirable. As a lawyer, I'm kind of taught to find a retaliation in that. And again, we're not among friends, so I don't have any qualms about stretching that. And then if the EEOC officer does not find in your favor, okay, fine. There's no penalty. You haven't lost anything. But a jury might agree with that, or they might agree that 2 of the 5 things are retaliation. They might say, the other ones are kind of arguable. We're not going to find on that. But eating in the lunchroom separate, that had to be retaliation.
So when it comes to dealing with retaliation, that is something that would work in a court case. How long roughly would that process be for dealing with retaliation?
Are you talking about like when the case is filed all the way to a verdict kind of a thing?
Yeah, because people are going to face this.
A couple of years. At least a couple of years.
So this is a couple of year thing. So that's not an answer. Because people are going.
Right. No, it's not a practical answer. No, it's just one. It just gets you an A on the law school exam, but it doesn't. Yeah, no. I bring 3 colored hats with me now when I do my presentations. You're gonna laugh at this. I bring props now. I do, and it actually helps. I bring a red hat. That's my activist hat. I say you're going to get 3 lawyers in here tonight. They're all going to be named Mitch Marczewski. And I've got my red hat activist, so I might be answering your question as an activist. Then I have, it's my black hat, kind of matches my dark blue suit. This is my lawyer, attorney, and counselor at law. This is the Mitch Marczewski. When you're in my office and you tell me about your car payment and your kid wanting to go to college and this and so forth. And then I've got my my light blue hat on, which is the student who's still back in law school wanting to get an A on the exam and give the answer just the way it is, that does not have a client, doesn't have to worry about can they afford what I'm writing in my answer. You just write it all down, everything, every law that applies, every motion you can file, every expert you can hire, because you're in law school and you want to show the professor you've thought of everything, even though what you just wrote is going to cost, $80,000 right out of the gate. You don't think about that. So it just depends on what hat I have on. I decided that was the best way to do it. And they'd ask a question. I'd say, well, let me give you my activist answer, put the red hat on, give them the answer, and so on. So, yeah, I mean, that's not a practical one in the end, unless it's right. Yeah. The one that you really have to have on is the attorney and counselor at law hat. That's really the one you have to have on most of the time. With your clients, it has to be on all the time, actually, completely all the time. When you're outside your office and you're teaching somewhere, you're at a rally, you're speaking or whatever, and, maybe just having some fun, you're, off the clock, then you could have those other 2 hats on. Or you use the other 2 hats for illustration purposes to help you do a better job when you have your attorney and counselor at law hat on. You don't want to bankrupt your client, paying your fees. That's not, because under the attorney ethics, you always have to do what's in the client's best interest, even though it earns you less of a fee. That's absolutely required. And I mean, I love the profession that I'm in. I mean, I absolutely love coming to work. It's just great being able to help people in a very meaningful and in a big way. I really like the job. I'm not one of the, I'm not one of the ones that says I hate being a lawyer. It's so frustrating. I mean, there's frustrations to it. I must have found a way to deal with them.
Yeah, you're still a lawyer, so somehow.
You're right, yeah.
And you're also on our side. You're on the side of angels, so you're obviously not one of the bad ones.
Yeah,
so,
that's true. Yeah, I could be in the big tall buildings,
shiny glass walls. And, oh yeah.
Oh yeah, getting, but it's just not me. I would not be happy. I mean, I don't turn money down, but I've learned, like many of us have, that's, it's important. I tell my kids, money's important. It's in the top 5. Money's in the top 5. It's not number 1, but it's in the top 5. You can't live
without money, unfortunately.
Yeah, right.
That's what they're doing to these healthcare workers right now, and the federal contractors and workers as well, and trying to figure a way out for them is that's got to, and one in a reasonable time frame is paramount, unfortunately. And I'm just basically spitballing here because I'm trying to figure out what possible way out, and unfortunately the retaliation is that's not one of them. It sounds like it could it get accelerated more if enough money was thrown at a perfect case?
I think so. I mean, to be frank with you, in some senses, my brain doesn't go there very often because it's just generally a very remote possibility. So I mean,
we've got a lot of people who are very decent, very wonderful, in perfect situations with absolutely no reason for them to be doing these kinds of things to them. So, I mean, that's one thing where it's like, and the reach, I mean, because of what I've been doing for the last, whatever months, years now, there, and also what others have been doing. There are networks out there. I would imagine that if we can find those perfect people, we probably can. And that's the thing where we need to know what the perfect people are, and then we need to reach out in these networks, these really big networks, and find those perfect people, and that could be faster than a couple of years because we need to set that precedent. And once we do, then we can help the next down the line. But it's not something practical for an individual. That is key.
That is correct. Yeah, it really is. It's correct. Now I'll just point out something on a side note. On a temporary restraining order, one of the requirements is showing the court you have a high likelihood of success on the merits in the case long term. So what's happening? It's like a Saturn rocket, and don't quote me on these percentages, but it burns 80% of its fuel getting out of the 130 miles of our atmosphere. Then it burns the other 20% going to Pluto or Uranus or wherever it's going. And these lawsuits are the same way, especially when you're wanting temporary restraining orders, is you've got to do like the entire research for the whole case
right up front.
And show the court we're entitled to a restraining order, Your Honor, because it's very likely we're going to end up winning this case. And you haven't put any witnesses on or evidence or anything. And that is a tall order to get a temporary restraining order. That case has to be extremely strong. From the legal, actually more on the legal side of things than even on the factual side of things. And so, yeah, that's just what is required. So people that have gotten those, like I know Matt Staver out of Liberty Counsel, they've gotten the 2 that I talked about earlier, and many, many more. They're good at picking them. They pick winners. They turn down hundreds of people, not because they don't think that they have
you need the winners, because once right. You have the winners, then the ones that are a little less perfect can ride on those coattails, and the more winners you have, you go right on down the line. So yes, you find your perfect person, and then you get your slightly less perfect, and then your slightly less perfect, and on until it becomes the overwhelming basis. All
Yeah,
right, so we have been going on for a long time here. We should probably start wrapping up. There are a few more questions, so I think we'll end with those few questions there. This is kind of maybe the follow up to that earlier question I had about the unemployment. So I think this is what she's asking here, that they're saying that you can't get unemployment if they fire you for not getting the shot. Is that true?
my my position is no. The standard for receiving unemployment is they have to have fired you for a just cause. An employee asserting their constitutional right to a medical exemption and firing them for that is not a just cause.
But firing somebody who just stops working because they've been paid a lot less, that is something you can get unemployment denied for.
That is correct.
Okay.
Yeah, that is not a good way to go. You're going to want to show up for work. If you don't show up for work,
but at that point you have to get another job, because and unfortunately that's what they're doing. They're clearing out the hospitals of anybody who has any spine, and that's very unfortunate. There was another one. Here's another question here. Could this one work?
Okay.
Would it work to ask them to sign for being liable for any adverse effects you might have from taking it? Is that a kind of safe way to fight these mandates, kind of thing? But I don't know where that would fit into this whole process.
Yeah. If it's, I guess I can. That question could have two perspectives. using the word them and they. The employer's not going to sign.
Lawyers.
I'm sorry.
No, lawyers. I mean, them and they. Okay.
Right. Yeah. Yeah. I get it. I mean, I'll be taking my lawyer hat off, and I'll be like a normal person and take my German Shepherd for a walk when we're done. But yeah, no, I get it. The employer is not going to sign anything. Whether you should sign it's another ridiculous type thing where you're going to have to make a judgment on it. I don't think, let's put it a couple ways I can answer it. Even if you did sign it, I want to see them prove that you were the one that gave everybody COVID. I want to see that case. I will travel anywhere in the country where somebody's going to say everybody in our plant, or even one person in our plant, got COVID from you because you didn't wear the mask. I really want to see that case, because I don't think you can prove that at all.
No,
that is such a bogus joke. In fact, there's a case, I think I forget the name, but somebody's suing the city of Washita, or the Washita, Wisconsin School Board, over a very similar thing. And I read that thing, and it is just such a bogus, that if you don't make everybody mask, then the school board's going to be responsible for the kids that get COVID. I'll bet that case is dismissed by now. I read the pleadings on that and the motions on it. It is just total bogus.
Well, what they've done in the state of Ohio, I mean, it's no longer in effect. I'm not sure if you're familiar with House Bill 606.
No.
So that actually, I believe, is the basis for all the mask mandates and all that kind of stuff, because the way it was structured, it was billed as a bill to protect businesses and schools and all those things from liability. Yes. And the way it was phrased was that if so long as the business or school took the suggested protective measures, they were not liable. And to me that says, well, if they're not liable so long as they took appropriate measures, that means if they don't take appropriate measures, then they are liable. And I believe that was the basis for all of these businesses going nuts on the whole masking and enforcing all these crazy rules, because it's the law.
Yeah, the thing is, you still got to prove your case. I know I'm kind of chuckling here in a kind of a serious subject, but I mean, I've done trials. You have to put testimony on. You have to have a direct connection.
Yeah, I think they're just scared of
I mean, it's just
threat with liability, and they're just like, oh my goodness, just doing the court case and we'd be broke, and so they just go along with it.
Right, yeah, yeah. And you have like it, especially in criminal cases, and I know this is not criminal, you have chain of custody. Like you have every detective that touched that piece of evidence, and when they examined it, they put it back in the bag and they tape it up and they sign it. I mean, I've been in evidence rooms examining evidence, and the procedure is just amazing, and they have logs and everything. You know, the cocaine rocks or whatever it is, the gun, or even the money that, you know, you know, you got to establish that in front of the jury. And then I'm thinking, okay, so you're in a civil trial, you're going to establish some sort of chain of the traveling of this virus through the air. Yeah, good luck with that.
Well, especially since, you know, it gets aerosolized, and especially with the masks, it even increases aerosolization. And once it's floating in the air, it's going to take a very long time to settle. So it could have been somebody there long before you ever showed up. All right.
Right. It's not provable. It's just not provable. But anyway, it's just another, we got a 3-ring circus, and it's just another bogus ring going on of many rings in this whole shenanigan that we're experiencing.
All right. Well, I think that's all the questions. I hope I didn't miss any there. And thank you so much for doing this with us and answering all my crazy spitballing questions there, because we need to find a way to get ahead of them. And
we're going to find it. We're going to find it. I know we are. We're going to find it. I know. I just got a feeling. I'm not sure exactly what it is, but we're going to find it, man.
Got to figure it out. And anybody watching, if you've got any ideas, I mean, go contact Mitch and ask him if it works, if it could work. All right. Well, thank you everyone for joining us. Thank you for joining us here too, Mitch. It's been really interesting. So good night, everyone.
Good night.